We'll start calling the docket this morning. First case the court's calling is 2018-400, State of Arkansas versus Robert Penny. Mr. Penny, Mr. Pastine is representing you, appointment from the Public Defender's Office, and entered a waiver of arraignment on your behalf. This matter is on the Division 4 docket, and we're setting it for, by scheduling order, your next appearance in court will be the 29th of November. That's for us to check the status of the case, make sure all discoveries in motion, etc. You'll have a pretrial scheduled for March 7th of 2019. You'll have a plea deadline for May 16th of 2019, and your trial will be set up for the week of May 20th of 2019. Those will be the dates on the scheduling order. All right, sir, you may be excused. 2018-416, State of Arkansas versus Mark Nightman. I'm sorry, Matthew Nightman.
Yes, sir.
I'm sorry, I misspoke. This matter is for arraignment this date. Have you made arrangements to be represented by an attorney?
No, sir, I haven't been able to get a hold of an attorney.
Okay. What are your plans? Are you planning to hire an attorney?
I plan to get a public defender.
Okay. Well, the way you do that is you get the applications. They're there available to you there at the jail. You fill it out, sign it, and turn it in. It will get to the Public Defender's Office, and the appointment of a public defender will occur out of that process. So get that done as soon as you can. Your case, you're for arraignment on a charge of possession of drug paraphernalia, Class D felony. On that charge, how do you now plead?
Not guilty.
I'm noting your plea of not guilty, and we'll set this matter down for trial in accordance with the scheduling order of this court. That scheduling order will provide that you'll next be in court for November 29th. That date will be to check the status of the case and make sure all the arrangements have been made with regard to discovery. You'll have a pretrial date set for March 7th of 2019. Your next appearance is November 29th of 18, then March 7th of 2019. Then I'm going to put it down for May 16th of 2019 for your plea deadline hearing. I think this is just a mistake on the we need to see if we can't correct that, the date that's listed on the scheduling order for the final hearing there. And I'm setting it for May 16th of 2019, and your trial will be scheduled for May 20th of 2019. All right?
Your Honor?
Yes, sir.
Your Honor, I was wondering if I could OR. There's a lot of medication I take that I'm not able to get to unless I get out of here, and I've gout really bad. It's getting hard for me to get around here.
Well, I'm just going to tell you, Mr. Nightman, I'm very hesitant to be releasing you OR to take medication when the charges are against you relate to drugs. There's a fundamental inconsistency in that picture. So, you know, this is why you need an attorney to investigate and present this issue to the court.
Your Honor, I think he indicated he was going to be filling out an application for the Public Defender Office. If the court would bring him over when you bring over inmates, if he'll fill out an application, I think there is a good chance we can totally resolve this case today, Your Honor.
All right, Mr. Nightman, did you hear what Mr. Cooper said?
Yes, sir, I did.
Mr. Cooper's from the Public Defender's Office. If you'll fill out and make that get that application done, so that it's all filled out, we can process it this afternoon when we bring you over. That's probably going to be around 2:30 that we'll be getting to that. All
Okay.
right, you may be excused at this time. 2018-424, State of Arkansas versus Samantha Lafferty. Ms. Lafferty, you're appearing at this time for purposes of arraignment in this case. Have you made any arrangements to be represented by an attorney?
I have a lawyer, but I haven't been able to get a hold of her since I got arrested, sir.
What is her name?
Her name is Kimberly. I forget her last name. I apologize.
Kimberly?
Johnson.
Yes, sir.
Johnson.
Yes, sir.
Is that court-appointed? Is that the court-appointed attorney from juvenile court?
She's the one that was with me at DHS.
You know, I don't believe Ms. Johnson's allowed to represent people in criminal court, Your Honor, on her contract.
This is a completely separate proceeding that you're involved in at this point than what you were involved in juvenile court. Kimberly Johnson represents parents in juvenile cases where children are, where there are issues of abuse or mistreatment with regard to children, and she will continue to be your attorney in juvenile court. But she's not allowed by the contract that she enters into to represent people in juvenile court to represent you in a criminal case. What I'm advising you is you have a constitutional right in this criminal case to the representation of an attorney in order to follow through on that. Your choices are to go out and hire the attorney of your choice, in which case the court doesn't get involved. However, if you cannot afford to hire a private counsel, then you'd be entitled to the appointment of a lawyer to represent you in this case, and that lawyer would come through the public defender's office. To secure a public defender, you'll need to fill out an application for the public defender's office services. Those applications are there at the jail. The jailer can give you one right now. You fill it out, read it over, fill it out, sign it, and turn it into the jailer, and they will get it into the process, initiate the process, so it'll get to the public defender's office. It'll make sure it goes before a judge to make the appointment for you.
Yes, sir.
So that's your situation, and it's extremely important in your best interest that you make those arrangements. So I would, unless you're in a position to hire a private counsel, I would strongly urge you to fill out that application and get that process started. Having said that, on the charges that you're charged with, which, as I say, are battery in the second degree, it's a Class D felony, endangering the welfare of the minor in the first degree, Class D felony, 2 counts. On those felony charges, how do you now plead?
I plead not guilty, sir.
I'm entering your plea of not guilty here on the record at this time. That'll show that. This case is assigned to the Division 4 docket. That's my docket. I'm going to, at this time, enter a scheduling order that will set your case, this is the order that sets your case for further proceedings. You'll be ordered to appear on November 29th, 2018, and that's just for for initial appearance to check on the status of the case. March 7th is set down for your pretrial of 2019 is set for your pretrial date. May 16th is set for a plea deadline date, and your trial is set the week of May 20th of 2019. Now, that order is in place just so that everybody can plan on that, and what you really need to do right away is get your attorney in place. So
Yes, sir.
fill out that application. And your attorney can kind of guide, from that point on, your attorney can guide you for it. As was set out in that scheduling order that I've already, is already been put in place, I'm advising you that it's your obligation to, once you get the public defender appointed, it's your obligation to get in touch and stay with in touch with the public defender's office. As long as you're in jail, the public defender's office will, defender will come see you. If you're not in jail, that is, if you bond out, then it's your obligation to call the public defender's office, schedule an appointment, and do that immediately upon getting out of jail, and keep that appointment, get in to see the public defender's office, and you're court ordered to do that.
Yes, sir.
I say that I'm not threatening you, but I just want you to understand what I mean is if you don't do that, you're subject to being held in contempt of court and put back in jail for not following through on that court-ordered obligation to get in touch with the public defender's office. So make sure you do that, all right?
Yes, sir.
Now, has there been any discussion between counsel about the bond in this matter?
You know, because she's not had counsel, we haven't had to talk to anybody about the bond, Your Honor.
That's true. I'm sorry.
It's okay.
$25,000 is what it's set right now.
And the state thinks that's appropriate based upon what the charge is in this matter, Your Honor.
Right. The court will say that it will consider, I don't know anything about this individual's circumstances or situation. Court will consider a bond reduction, but once, I need to have counsel contact you and discuss that with you, and then get in touch with the court about modifications. All right?
Can I go ahead and say that besides getting a speeding ticket and being in trouble for driving on a suspended license, I've never been in trouble for any sort of drugs, and I've never been in trouble for any sort of fighting. And I can tell you right now that I have never laid a hand on my child in a negative way.
All right.
Nor have I ever tried methamphetamines or anything such as that.
We are, this time, we are not trying or deciding your case. So
I know, I'm just saying this because literally this is the first time I have ever been arrested. And I have a family out there besides needing to fight for my own child that also needs me at this time, let alone the fact that my landlord is already evicting us because I was arrested and we have to find somewhere else to live. And I need to be able to bond out soon.
okay. This is why I'm emphasizing to you how important it is you get your attorney appointed and get that attorney working on your behalf, all right? That's who I will look to receive more information about your case, and as I've already stated, I'm willing to review the bond that I'm setting based on more information that's available to me. But you need to get the attorney in place and then have that attorney contact the court, and the court will discuss with the attorney and with the state what we're going to do on bond.
Yeah, and we're having someone go over to the jail at lunch, so she'll be one of those that we visit with, and she can fill out an application, and we can bring that back if that's her desire, present that to you this afternoon, and then
Very
if
good.
we are appointed, I'll get her to the jail and see her. Obviously
Very good.
not today, I will not.
Yeah. All right. So you may be excused at this time. 18-435, State of Arkansas versus Elisha Zachary Adams. Mr. Adams, you're before the court for arraignment on charges of possession of defaced firearms. That's a Class D felony, and possession of firearm by a certain person, a separate Class D felony. Possession of controlled substance, a Class D felony. Possession of drug paraphernalia, Class A misdemeanor, and simultaneous possession of drugs and firearm, a Class Y felony. Have you made any arrangements to be represented by an attorney?
No, Your Honor.
All right, the court would simply inform you you have your absolute constitutional right to an attorney. What that means is you have the right to hire the attorney of your choice, and the court doesn't get involved in that hiring. It's a matter of private contract between you and the attorney you choose to hire. However, if you discover in that process you cannot afford to hire an attorney, the court is advising you you're entitled to a court-appointed attorney. To secure a court-appointed attorney, you'll need to make application to the public defender's office. Those applications are there in the jail. You ask the jailer for one, fill it out, sign it, and turn it into the jailer, and that'll get into the hands of the public defender's office. So that's how you secure an attorney. On the charges I read off earlier, that is possession of a defaced firearm, D felony, possession of a firearm by a certain person, Class D felony, possession of controlled substance, methamphetamine or cocaine, Class D felony, possession of drug paraphernalia, Class A misdemeanor, and possession of drugs, simultaneous possession of drugs and firearm, a Class Y felony. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty on the record. Your case is set on Judge Putman's docket. I'm ordering you to reappear in front of Judge Putman on October 4th. Excuse me, I just discovered there's an amended information. There's an amended information, so just to make sure, in that amended information, you're charged with possession of a defaced firearm, Class D felony, possession of a firearm by a certain person, Class D felony, possession of controlled substance, Class D felony, possession of drug paraphernalia, Class A misdemeanor, and simultaneous possession of drugs and firearm, a Class Y felony. On those charges, how do you now plead?
Not guilty.
All right. Court is noting that plea of not guilty, setting you to reappear in front of Judge Putman on October 4th. You may be excused at this time. Dylan Speckman, do we have a number on Dylan Speckman?
18-433.
Mr. Speckman, the court, you're before the court today on the following charges: possession of a controlled substance, Class D felony, resisting arrest, a Class A misdemeanor, theft of property, a Class A misdemeanor, and theft by receiving a firearm, apparently a stolen firearm, a Class D felony. On those charges, well, first of all, have you made any arrangements to be represented by an attorney?
No, I haven't.
Once again, I would advise you that you have the right to an attorney. That's an absolute constitutional right. You exercise that right by going out and hiring the attorney of your choice. If you're hiring private counsel, the court does not get involved in that process. It's just a private contract between you and who you choose to hire. However, if you cannot afford to hire an attorney, you're entitled by law to by the Constitution to representation of counsel, and the court will appoint an attorney for you. In order to establish that you cannot afford to hire any counsel, you'll have to fill out an application for the public defender's office and list what assets and liabilities you have in that. Those applications are there at the jail. You ask a jailer for one, he'll give it to you. You read it over, fill it out, and sign it. Turn it into the jailer, and it will get into the hands of the public defender's office to make sure a judge reviews it and makes the appointment if it's appropriate. So that's the process for securing an attorney in this in every jurisdiction. The court would ask you on the charges I read off, how do you now plead?
Guilty.
You said guilty or not guilty?
Guilty.
A court is not going to accept a guilty plea prior to you having contact and discussion with an attorney. You need to discuss that. The reason I say that is if I accept your guilty plea, I can go ahead and sentence you to the penitentiary right now. So you need to get the advice of an attorney. Just do that. So you've been told how to get an attorney and do that. I'm entering a plea of not guilty on your behalf here on the record on the charges that I read off. Your case again is on Judge Putman's docket. I'm setting you down to reappear next Thursday in front of Judge Putman. That's October 4th in front of Judge Putman. I would recommend that you get that application filled out today unless you're in a position to hire counsel. You may be excused at this time. 2018-336 State of Arkansas versus Ashley Partlett.
Your Honor, while you have Ms. Partlett available, would you inquire as to who is going to be her counsel, please?
All right. Ms. Partlett, I was just checking. You're here for arraignment. You appeared, according to the file, on August 9th in front of Judge Putman. And then you appeared on August 16th in front of this court. You were ordered to reappear on August 30th to check attorney status on that date, and then on August 30th you didn't appear, leading to the issuance of an alias warrant. That warrant was returned on, was served on September 11th and returned on September 17th. According to these records, I don't see that you've ever been arraigned on the charges. Have you made any arrangements to be represented by an attorney?
No, Your Honor.
Okay. What are your plans in terms of making an attorney? The right to an attorney is an absolute constitutional right. It's your right, and you are the one who has to exercise it. It's not going to happen magically. So
I did fill out a form, though, I believe, actually.
When did you do that?
My mother actually turned it in to you guys. I've asked for a form here, but I never did get one, but my mother did turn one in.
Your Honor, we don't have the form, but this is similar to a previous situation. If the court would bring her over, she could fill out the form here, and I think we may dispose of her case today.
All right. I'm going to direct that you'll be brought over later today.
Yes, Your Honor.
You may be excused for now.